Hi, students. This video lecture today is on search warrants. Searches that are conducted to gather evidence during a criminal investigations. A criminal investigation is a full search. The general rule is that the officer will have to have a search warrant to do that, or be searching pursuant to one of the recognized exceptions that we will talk about in another video. When we talk about a search warrant, there's a strong preference for a search warrant. Remember, when the officer is using a warrant, a search warrant, in this case, that search is presumed to be lawful, and the burden will be on the defendant to show that the search is unlawful. When there's a preference for a search warrant because the officer prepares the search warrant and an affidavit in support of the search warrant and presents it to a judge, and a judge reviews it, and a judge makes a determination that there is probable cause to issue that warrant, and then issues it. So there's a finding before the search of probable cause. And there's a strong preference under the Fourth Amendment that officers seek a search warrant before they conduct a full search. So when we talk about probable cause in a search warrant, there's three aspects to it. The officer is going to have to establish that a crime has been committed, that the evidence exists, and evidence exists at the location that the officer wants to search. This information has to be fresh. It cannot be old information. And also, the search warrant itself, there has to be a particularized description of the place that the officer wants to search, and a particularized description of the items that the officer is searching for. Now, this is directly from the Fourth Amendment if you read it. Why is that? Remember what I told you. One of the big abuses by the king was the use of these general warrants and writs of assistance, which were very general. They did not have a particularized description of the place to be searched or the property to be seized. The colonials wanted to prevent this abuse, and so they included the Fourth Amendment, which requires a particularized description of the place to be searched and a particularized description of the items that they want to seize. So that is very important. There's a scope to the search warrant, which defines what can be searched. So when you read the search warrant is directed to a peace officer, and it says you are to go to this particular place and search this place. And it could be a home, it could be a business, it could be a person, it could be a vehicle, it could be a container. It could be any of those things. And in a lot of cases, officers are searching more than one. They're searching for a house. They're searching also for the person and vehicles. That's a common occurrence, especially in drug cases that I've seen. So that's the scope. The scope of the warrant, it's where you can search, and it's right in the search warrant itself. The intensity is how well you can search. So for example, if you have a case involving a stolen television, and it's a 60-inch television, and you have a search warrant that commands you to search a house for that television, where can you search for the television? You can search anywhere that television could be found inside the house. Does that mean you can search drawers? No, because the television cannot fit in the drawer. So you have to look at the search warrant, and the search warrant will define the intensity or how well you can search for those items that are listed in the search warrant. I included a sample search warrant. You'll see it in this particular unit. So open that up and take a look at it, read through it. You're going to see that that search warrant has three parts. Um, so actually, there's the search warrant itself, and that is the order that the judge will sign. And the judge basically says that I have found probable cause and issue the search warrant. And that search warrant will include the place to be searched and a description of the items to be seized. That is the search warrant. There is a separate document called an affidavit in support of the search warrant. The affidavit is written usually by a police officer, and the affidavit is the document that will contain the probable cause for the issuance of the search warrant. The affidavit generally is in three parts. The first part outlines the education, training, and experience of the affiant. The affiant is a person who wrote the affidavit. Typically, the affiant is a police officer. So it'll list the education, training, and experience of the officer affiant. Why is that there? That is there because the third part to the affidavit is the officer's opinion. And if the officer has specialized or has an education, training, and experience in a particular field, then the judge can find that he's an expert, and that opinion, which is in the third part of the affidavit, is the officer's expert opinion. So there's two types of opinion. There's lay opinion and expert opinion, but an expert opinion, a judge will give greater weight to that opinion than just a layperson's opinion. So that's why the affiant puts in the beginning his education, training, and experience to show to the judge that that you are dealing with an expert. Now the officer can't write I'm an expert. The officer has to write his education, training, and experience, and the judge makes a determination based on that if the officer is an expert, and then the weight to give to his opinion at the end, which is the third part. So that's the first part, education, training, experience to establish he's an expert. The second part is the officer's investigation. In the sample warrant that you will open and read, it's a warrant, it's from Los Angeles Police Department to search, I believe, a house, but it's a drug case. So the the officer sets forth his probable cause and he receives information. And the information he receives is from a confidential informant. Um, and I believe it's not only a confidential informant, it's a confidential, reliable informant. So there are different types of informants. For example, there's what we call a citizen informant. A citizen might not give the name, but they are a citizen. The only reason they're calling the police is to help police solve the crime. They have nothing to gain from making this report. And if they're a citizen informant, they're deemed reliable. Sometimes people give information for all kinds of different reasons. Maybe they're working off an arrest themselves. So a person's been arrested, they get flipped by the police, and in agreement for reduced um, or consideration on their criminal case, they agree to provide information. So that person becomes a confidential informant, and there has to be some reliability established. So maybe that reliability is because they gave information in the past that has been verified. Maybe because they're reliable because they made a statement against their own interest. Uh, maybe they're reliable because other informants have verified their information. But they have to be reliable, confidential, reliable informants. So there's you have citizens informants, you have confidential, reliable informants, and then just have confidential informants that really they're giving information, but the reliability has not been established. If you have just a confidential informant, well, then you're going to have to corroborate that information and show that the information is reliable. So in this particular case, he has the information from the informant, and that information establishes that the crime of possession has occurred, that there's evidence of drugs in the home, and it's likely that the evidence will be found in the home. And after reading that, the judge would find probable cause and issue the warrant. So then the officer would take that warrant. He would gather a group of other officers. They would go to that home. They would approach the home. It would have a tactical plan to serve the warrant. It's very dangerous. They would knock on the door, announce their presence, give the person an opportunity to open the door. That's required under the penal code. And then if they opened the door, they would present the warrant. If they didn't open the door, then the door could be forced open. If they're knocking on the door and they hear people arming themselves or destroying evidence, they could go in enter the premises forcefully. When I was a police officer, I was a police officer for 10 years. I worked a patrol for 3 and detectives for 7, and I worked all types of crimes. I started in property crimes, worked auto theft for a long time, and then I also worked crimes against persons, robberies, assaults, and those kind of things. And every case that I every case that was assigned to me, I always read it, and I always tried to see if I could write a search warrant. Why is that? Well, not only are you able to obtain the evidence of your crime, but if the individuals that are there, they don't know you're coming. And when you get there, you can take charge of them. You can separate them, you can detain them, you have a chance to interview them. If you have evidence, you can then confront them with the evidence. And it really is a way to move your case forward to a successful outcome. So I always tried to write a search warrant. Every case that that was assigned to me, I always asked, "Can I write a search warrant here?" And that's what I would do. Um, so anyway, so search warrants are it's a very valuable thing. Once you serve a search warrant, you collect your evidence, then maybe you made an arrest, maybe you didn't, but that will allow you to further your investigation. Maybe the search warrant is the end of your investigation. That's all you needed to do. Or maybe that's just part of it. Maybe you're going to write more search warrants. Maybe you're going to interview more people. But eventually, you're going to write, as a police officer or detective, you're going to write all your reports, your police reports. There's the initial crime report. You're going to have your follow-up supplemental reports. You're going to document the obtaining of the search warrant and serving the search warrant in a police report, all your interviews, and you're going to wrap up your investigation. And then eventually, if you feel that you have enough to charge this particular person, you're going to, as a detective or a police officer, contact a district attorney's office. Then you will present your entire case to them. When I worked as a police officer in Concord, California, I would actually call up the DA in Contra Costa County, and I would make an appointment to present my case to that prosecutor. So I'd have my reports. I would hand them a copy of the reports, and I would explain to the prosecutor uh, my case, and the prosecutor would review it and then decide what charges. Now, sometimes they would decide, okay, we'll charge this person, and then the person would be charged, a warrant would be issued, and so forth. In some cases, the prosecutors say, "No, I don't want to charge this yet. There's something missing here, and I want you to go and I want you to do a few more things. I want you to interview some more witnesses. I want you to process some evidence. Think about maybe another search warrant." those kind of recommendations. So you take the case back, you would conduct your additional investigation and then bring it back. And in some cases, they would charge the person, but they would make a recommendation, or they would require you to do some further investigation. So they would still charge it, but they would have you do some additional follow-up investigation. And that would all be documented in the prosecutor's file, and then they would make sure that that has been done. And so anyway, that is really all about search warrants. Take a look at the sample search warrant. It's not very long, but it gives you an idea of, you know, what one looks like. Search warrants, I mean, I have written many, many myself. I've served a lot of my own. I've been with other officers serving theirs as a prosecutor. I reviewed them. I have defended them in court. As a judge, I've issued them. There's all kinds of search warrants. There's search warrants for homicides, assaults, and rapes, and drug cases. There are just a variety of situations where an officer will write a search warrant. They write a search warrant for records, phone records, Facebook records, Instagram records, all kinds of social media type records. They'll write a warrant to install a tracking device on a vehicle, or I mean, it just depends on the case and what they need. And if they need particular evidence from a particular place, the best way to get it is to write that search warrant. I think that for me made it my career in law enforcement honestly very interesting, because every case I had was a little bit different. So it was always a rewarding experience is to write a search warrant to see if you could not only obtain the evidence, but obtain um, additional information that would move your case to a successful prosecution. And I would, if you're going to be in police work, I don't think you'll find anything better to do. If you're not in police work, that's okay. At least you know what the requirements are. And again, I'm a big believer you have to know your rights in order to defend your rights, right? So it's important for you to know them, and how it all works. So anyway, I'm going to end this video. The next video lecture will be on the exceptions to search warrant. There are a few that I'm going to discuss. There's consent to search, search incident to arrest. There's the automobile exception, and exigent circumstances. And there's a few more, but I'm only going to cover a few, the ones that are most widely used by law enforcement. All right. Well, until then, take care. I hope you're enjoying the class. I hope it's clear. I've tried to lay this out in a way that is clear. Generally it requires you to read, and then to watch the video, and watch other videos, or participate in discussion. But I hope it's broken down into chunks of material that it's clear for you, and easy to maneuver through. Okay. Anyway, so again, take care, and I will talk to you later. All right.